Good afternoon. By a unanimous vote of all those participating, the Supreme Court en banc denied with finality the motion for reconsideration filed by the House of Representatives, which sought to reverse the Court's July 25, 2025 decision that declared the articles of impeachment against Vice President Sara Duterte unconstitutional. It affirmed that the fourth impeachment complaint transmitted to the Senate on February 5, 2025 was already barred by Article 11, Section 3, Subsection 5 of the Constitution. Associate Justice Alfredo Benjamin Caguioa took no part. Associate Justice Maria Filomena Singh was on leave. The Court clarified the following points. First, the first three impeachment complaints filed in accordance with the first mode of initiating an impeachment, that is, Article 11, Section 3, Subsection 2, were not placed in the order of business within the required 10 session days. Session days as used in Article 11, Section 3, Subsection 2, or for purposes of the first mode of initiating an impeachment complaint, does not mean legislative session days. A session day for purposes of Article 11 in the Constitution was given its plain and ordinary sense, which the Court interprets to mean a calendar day in which the House of Representatives holds a plenary session. Second, the Court reiterated Gutierrez versus House of Representatives. However, it further elaborated that an impeachment complaint filed in accordance with the first mode of impeachment, which is Article 11, Section 3, Subsection 2, is deemed initiated for purposes of the one-year bar in Article 11, Section 3, Subsection 5 when a properly verified and endorsed impeachment complaint is referred to the Committee on Justice. B. A properly verified and endorsed impeachment complaint is not placed in the order of business of the House within 10 session days or referred to the Committee on Justice after it has been put in the order of business within 3 session days as required by Article 11, Section 3, Subsection 2 of the Constitution. Or C. No articles of impeachment are transmitted to the Senate before the House adjourns sine die. This means that the initiation of an impeachment complaint must occur during the term of Congress. Third, the Court affirmed the power of the House of Representatives to promulgate its own rules on impeachment. However, it clarified that Section 2 of the House Rules, as it is currently worded, requires the referral to the Committee on Justice, even when it is filed through the second mode. The second mode is provided in Article 11, Section 3, Subsection 4 of the Constitution, where the endorsement of at least one-third of the members of the House of Representatives would be sufficient to transmit the articles of impeachment. In view of the current wording of Section 2 of the Rules on Impeachment, as drafted and promulgated by the House in its 19th and 20th Congress, the House may, optionally, upon its own prerogative, refer an impeachment complaint already endorsed by at least one-third of all its members to the Committee on Justice, but only for the following purposes. Number 1, to ensure that the endorsement of the members of the House is verified. Number 2, to confirm that the evidence supporting the grounds in the complaint exists and that every member of the House has been given a copy of the complaint, as well as the evidences supporting it. And 3, to respect the committee's prerogative to consolidate different formulations of the complaint, if any, so that only one complaint is endorsed to the plenary for transmittal to the Senate. The Court observed that there is a fundamental difference between the first and second modes of initiating impeachment complaints. Thus, it said, and I quote, Article 11, Section 3, subsections 2 and 3 cover the first mode of initiating an impeachment complaint. Article 11, Section 3, subsection 4 covers the second mode of initiating an impeachment complaint. In the first mode, impeachment is initiated through the regular and deliberative process in the House of Representatives. A verified complaint may be filed either by a member of the House or by a private citizen with the endorsement of a member. Upon filing, the complaint is referred to the House Committee on Justice, which evaluates its sufficiency in form and substance and conducts the appropriate hearings. Only after favorable committee action does the impeachment process proceed further. This mode therefore emphasizes institutional screening and committee review. By contrast, subsection 4 introduces an alternative and a more direct mechanism for initiating impeachment. Under this provision, a verified complaint or resolution of impeachment signed by at least 1/3 of all the members of the House of Representatives immediately initiates impeachment proceedings. These provisions reflect a deliberate constitutional design. Subsections 2 and 3 provide a structured and committee-directed approach, while subsection 4 allows a streamlined initiation when a sufficient level of consensus already exists. Fourth, the court affirmed that due process of law applies to the impeachment process. It stated, and I quote, "The phrase right to life, liberty, or property should not be read with undue literalism. It must be accorded reasonable flexibility to achieve its intent of protecting inherent and inalienable rights that could not have been exhaustively articulated at the time of its framing. The Due Process Clause embodies a fundamental constitutional commitment to reasonableness, fairness, and non-arbitrariness. It envisions that we cannot have a true democratic and republican or representative state that is arbitrary and unfair. However, due process as it applies to the impeachment process is sui generis or in a class of its own. Full-blown trial happens at the Senate. At least for the second mode of initiating an impeachment complaint, it only requires 1. The grounds invoked in the complaint or resolution are those contained in Article 11, Section 2 of the Constitution. 2. The procedure is governed by the rules on impeachment promulgated by the House prior to any filing of any impeachment complaint. 3. As already provided by the current House rules on impeachment, all endorsing members should have been given a copy of the complaint and all its supporting evidence. The court also noted that the transmittal of the articles of impeachment should be done in a plenary session of the House, providing all the members of the House with full copies of the complaint and its accompanying evidence mentioned in Rule 4, Section 14 of the House Rules on Impeachment. Transmittal to the Senate, however, requires only a vote of 1/3 of its members for the first mode of initiating a complaint, or proof of the endorsement of a complaint by 1/3 of its members for the second mode. Fifth, the operative fact doctrine cannot be invoked by the party directly responsible in the commission of an unconstitutional act. Thus, it does not apply in this case. Finally, the court noted all the motions for intervention and pleadings filed by individuals who were not parties to the case. This resolution is immediately executory upon digital service on all parties in accordance with AM number 25-05-16-SC or the guidelines of the transition to electronic filing in the Supreme Court. No further pleadings will be allowed. The resolution and the motion for reconsideration and the separate opinions are being uploaded and served on the parties. Thank you very much. Any questions?